Under Section 10 of the Theft Act 1968, a person will be guilty of aggravated burglary if he commits any burglary, and at the time of the burglary, has with him any firearm or imitation firearm, any weapon of offense or any explosive. According to Section 10(1)(a), a firearm includes an air gun or air pistol, and imitation firearm means anything which has the appearance of being a firearm, whether capable of being discharged or not. Under Section 10(1)(b), a weapon of offense means any article made or adapted for use for causing injury to or incapacitating a person, or intended by the person having it with him for such use. Section 10(1)(c) defines explosive as any article manufactured for the purpose of producing a practical effect by explosion, or intended by the person having it with him for that purpose. The maximum sentence of life imprisonment is set out in Section 10(2). The relevant time for possessing the weapon depends on whether it is a Section 9(1)(a) offense or a Section 9(1)(b) offense. If it is a Section 9(1)(a) offense, then possession must be at the time of entry. If it is a Section 9(1)(b) offense, possession must be at the time the ulterior offense is committed. In R. v. O'Leary, 1986, the defendant entered a house without a weapon. Once inside, he took a knife from the kitchen and took it upstairs to effect the burglary. It was held that as the offense was charged under Section 9(1)(b), there was no requirement that he had the knife at the time of entry. His conviction was upheld. There is no need to establish the defendant intended to use the weapon in the burglary. In R. v. Stones, 1989, the defendant was caught by the police in the course of committing a burglary. He had a knife on him at the time and was convicted of aggravated burglary. He appealed, contending that he had no intention to use the knife in the burglary and was only carrying it as the lads from Blythe were after him. His conviction was upheld. Possession of the weapon at the time of the burglary is all that is required for aggravated burglary. There is no mens rea as to the possession of the weapon. In summary, aggravated burglary under Section 10 of the Theft Act 1968 is where the defendant commits a burglary and at the time of the burglary has with him any firearm or imitation firearm, any weapon of offense or any explosive. If it is a Section 9(1)(a) offense, then possession must be at the time of entry. If the burglary is under Section 9(1)(b), possession must be at the time the ulterior offense is committed. It is not necessary to demonstrate the defendant intended to use the weapon, firearm or explosive in the burglary. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.elawrevision.org.uk for revision games and quizzes. Thanks for watching.